Welcome to the Practice Podcast, a show created by lawyers to help lawyers in life and business without all the complicated lawyer language. Let's welcome Bast Amron founders and your hosts, Jeff Bast and Brett Amron.
Hi, Brett.
Hey, Jeff.
How are you?
I'm good. And you?
Great. Happy to be here. Always happy to be recording the Practice Podcast with you. I wanted to talk today about, it's actually one of our core values that we communicate. And it seems like pretty generic. You know, you communicate, yeah, everyone communicates, but I suppose it requires some clarification that it really means we communicate openly, honestly, frequently, effectively, succinctly. There's so many different ways communication can be important, and so many lawyers fail at it, right?
Yeah.
It's like failure of communication is the number one reason why lawyers get ethics complaints or client complaints.
I don't know that statistic.
I'm pretty sure that Brian,
I believe you.
I'm going on record as quoting Brian Tannenbaum. I'm pretty sure Brian has said that to us at some point, or if it's not the top, it's one of the
lack of communication. Sure.
Yeah, I think the failure to communicate with clients is such a problem that's endemic in the legal field that I think it's probably worthy of discussion. But to us, I think it's so obvious because we hammer our people about it, and it's one of our core values. It's on the walls, it's on the website. But just letting clients know what's happening in their case or their matter is something that I think so many people just overlook.
Mm-hmm. Yeah, I would. I know you're not limiting it, but for our purposes of our discussion, we're not going to limit it to clients and communication with clients. It would be communication with your fellow attorneys within your firm or staff within your firm, opposing counsel, judges, mediators, everyone that you interact with on a daily basis. And, what I find is that is a skill that is difficult for lawyers and people generally to learn and to grab onto and to run with, and it's because it's the easier thing to just see something come in, let's say an email as an example, and just, I just don't know what to say. So I'm just going to say nothing.
Right.
And let it sit and let it sit and let it sit instead of, here's what I think I need to say. And maybe running it past somebody and saying, hey, what do you think about this? And then let me respond.
Right.
But doing nothing is not really, not ever.
It's the worst option.
Yeah, that's the worst option. Right. Even if the answer is to a client or, to anybody is, I received your correspondence. I will get you a substantive response tomorrow or, tomorrow or in 2 days, whatever it is, so that people know you're engaged. And to me, there is some method and to the madness of the timing of the response.
Right.
And either, the frequency with which you respond, how fast you respond, or how slow you may respond. Although you should, there should always be, right, a response. And I know there are some people that say to some things you shouldn't respond at all. But I think those circumstances are so few and far between. They're the exception. I'm talking about daily interaction with clients, with opposing counsel, with fellow lawyers or judges or whatever it is. I'm not talking about the sort of the outliers where people send you ranting and raving and all that stuff, which I agree. That should not be responded to. But the normal stuff within the practice should be responded to for a lot of reasons. Obviously, client relations are important, so they know you're on top of things. But opposing counsel need to know you're on top of things too.
Well, I think how, you raised a bunch of great points in there, but the timing of your response tells a lot to the other side. It can indicate, it may be intentional or may not be intentional, the timing of the response, but it may intentionally or unintentionally communicate, one, the importance of this issue. If the client is, dealing with a stressful situation and you don't respond to their email or their communication for a couple of days, you're kind of letting them know that this is not a top priority for you or it's not important to you. Whereas if you do, if it's a tough question I like your suggestion. You let them know, hey, I got this. I'm receiving it. You can say, you raise a really interesting issue. I'd like some time. I need to think about it. Or I want to confer with my colleague about it. Or I need to do some research. Just letting people know. But it's also, when you're in a case where maybe you're, say, the plaintiff and you're trying to move things ahead and the other side sends you something and you wait 3 days to respond, you're kind of letting them know this is, this case is not a priority. And when you want to accelerate things, they're going to kind of say, well, wait a minute, I tried to do this with you 3 days ago and you sat on it and didn't even get back to me or whatever it is, if a meet and confer or something like that. So, the timing is for sure critical. And I also think how you communicate, one of the struggles is, and you mentioned this too, is like how, this is how we communicate with judges, clients, opposing counsel, each other. I mean, one of the struggles is that they're all different. Yeah. How you communicate with the judge is way different than how you're going to communicate with your colleagues. But equally, obviously, equally, if not more important. I also think a lot of lawyers forget to just communicate with their client about what's happening, including, and I'm always amazed at this, successes. When you win, you're winning for the client. I think a lot of lawyers celebrate the win and forget I won this for the client. And they may just attach as an order granting the motion for summary judgment instead of, hey, we went to court. It was a 3-hour hearing, but we convinced the judge and we won. Congratulations. Here's what this means. It's not over yet, but step 1 of 5 is now complete.
Right.
To me, I don't think we can underestimate the importance of that.
Well, yeah, and even the quote unquote losses too, right? If you go to court, you file a motion, or setting expectations, and that's communicating. And it's not just email, right? It's over the phone or now by video conference or hopefully soon more in person. But I do think that it's how you set expectations even from day one and throughout, right? Like you file a motion, the client's like, oh, we're going to win, and it's, well, hold on. Here are some potential outcomes. Here are likely outcomes. And, we're going to go to court. And even if we don't prevail on this, here's why we are filing this motion.
Yeah.
In order to do this.
Right.
Within the scheme of this case and our representation of you, and I'm talking about a litigation or a bankruptcy case, here is why we want to file this motion, and here's what we would like to get out of it.
Right. It may not win, but it might, oftentimes we're filing a motion just because we want to tell the story or we want to get our position, in front of the judge, even if this particular motion may or may not win.
Right.
But you're also communicating that. And like you said, you're setting expectations. And to me, that is the backbone of honest communication.
Yeah.
Because that's another way I think a lot of lawyers fail is they just tell their client, yeah, we're going to win.
Well, it's what they think the client wants to hear.
Right. They tell them what they think they want to hear.
Right.
Rather than giving them
and it's badly when the outcome isn't what the lawyer has led the client to believe.
Right. And they're really doing the client a disservice.
Sure.
Because clients invest time and energy and obviously money in our services. And if you don't give them a realistic portrayal of the potential risks, the costs, everything else, then, they're making decisions based on bad information. And no one should ever do that.
Right.
Right. I mean, we've had, but I think it's also our job to funnel, if you will, the information, because sometimes litigation can be like drinking out of a fire hose. And if you just turn around and dump that information on the client and say, what do you think? You're making your client's life more difficult, but you're also not doing your job. Your job, we're lawyers. We're the lawyer. They hired us because we know the law, because we understand don't send your client a case and say, here's the case. Tell them what it means. That's why they have a lawyer, so they don't have to read a case. They have lawyers to read cases.
Yeah.
Distilling information is such a critical component of what we do and presenting it in a clear, understandable fashion for clients.
Even when, if you are asked to review something, I was asked to review something in a case and provide my edits, and I knew it was going to take me a little longer than I anticipated. And I just sent an email saying, hey, I'm working on it. I will get you my comments by no later than to let them know that it just didn't go off into the ether or that it's just sitting there.
Right.
Yeah. Again, just being thoughtful about, well, if I had sent that email, what would I want?
You're waiting.
Yeah, you're waiting for a response and it doesn't come. Right. And so I always sort of think about it that way. And I'm always amazed, and I think you hit it earlier, not just lawyers, but anybody in the daily life, like they don't respond and they're not responsive, and people are amazed, like, oh, thank you for the email or thank you for the response. And I was always amazed when I was coming up as a young lawyer and I did respond. I made the phone call or sent an email. And people were like, yeah, that I would never get that from another lawyer. It's just, and I was always amazed by that.
Right. It's just one of our core values. It's just something we do. It's just in our bones, but it's just not inherent in everybody.
Yeah.
And I think clients appreciate it. The other thing, like you said, not just clients. I keep, falling back to clients because I think they're the key example, but it's like how you present things too. If you want a response to something, if I have a whatever rule, if you will, if I'm asking 5 questions to somebody, I'm going to number them and make it very clear that I'm asking 5 questions and I want to answer to all 5 questions rather than just putting together a 12-paragraph email that they have to scroll for 5 minutes on their phone to see. How are they going to read this? What's it going to be like? Is this easy for them to answer? Are they going to, can they even keep track of all the questions I'm asking? And really, I kind of think it's our job to make life easy for the listener, whether it's a client or a judge or opposing counsel even. If I'm trying to convince somebody of something, it's my job to convince them, to make it easy for them to understand my position.
Right. Communicate.
Yeah. And to communicate clearly in a manner that here's my position and here's why I'm, conveying it to you, or here's why I'm sending you this email.
Right.
Your comment before about the response, you made the key connection is that if I was on the receiving end or if I was the sender, I guess that's employing empathy because you're communicating with someone in the way that you want to be communicated with. And I think that's what we oftentimes forget is that communication is a two-way street. It's a message I send, but it's also the message that you receive, Right. And if I send a message and I don't get a response, I might be thinking, oh, did he receive it? Maybe I didn't send it. Or maybe maybe the Wi-Fi was down. Maybe we start jumping to conclusions about what's happening. Is Brett busy? Did Brett miss this? Did he delete it? He's ignoring me?
I'm a big believer in responding when you see it, if you can. Not, well, let me wait. And it's because it's off hours or whatever. I'm not like that. Maybe I didn't come up that way. Right. I don't know. I'm not suggesting that, and I'm not suggesting that, listen, if you're with your family, if it's on a Saturday night or you're out, okay, I get that. Great. But I'm just talking about within the day or even at night sometimes, or even on the weekends. If I see an email and I can respond to it, I'm going to, because that's what sets you apart. Right. And that's what, how am I moving my client's interests? How am I moving the case I'm involved in along forward? Right. How am I progressing it? And if I see something and I can respond to it, then I might as well. Yeah. Like, why not?
Right.
We have these devices. Yeah, we have these devices. Right. Like, it's there. I'm doing it. That's fine. If it requires a more substantive response, I may respond and say what I said, which is, got it. I will review and get back to you.
Right.
To me, some would say, well, that's a non-response. No, it's not. It's not a non-response. Right. Yeah. You're communicating and conveying that you received the message, that you were going to review it. If it requires a substantive response or a review of a document, whatever it is, and say, I'm going to get back to you.
Right. And you're doing what you said before, which is setting expectations.
Right. And moving things forward and progressing. And that's what, to me, that's the thought process that every lawyer should have every day when they're doing something in a case. Not, I'm just pushing paper, or I'm just doing some research, or I'm just drafting something. Like, how does this fit within the larger scope of the representation and the interests of the client?
Right. Yeah, and it's also, that point about, responding to the email is also one of the points that Brett Spodak, who was a guest on one of our earlier episodes, taught us about, email inbox efficiency is just touch it once if you can.
Yeah.
If you have the email and you can respond, just respond to it. Why open it, close it, and then open it again and close it and open it 5 times before you respond? It's just terribly inefficient.
You're going to forget. I mean,
or more importantly, you're going to forget.
You're going to read it. It's going to be in your inbox. Your inbox is going to get more full with newer emails.
Right. It goes down the list.
And then if you scroll, then you'll see it again.
Right.
But when will you see that again? And so that creates all kinds of issues. We don't have time for that. But, so that's, to me, I don't stand on ceremony and say, I want them to think I'm too busy. And so I'm unavailable. And so I'm not going to respond.
Right.
I actually go the other way.
Let them know. Yeah. I mean, and I think the other, you're also sending a message to the other folks on the team, internally that, hey, I'm on this, I'm responding. And this is how, you're modeling the behavior, if you will, that you want, is when something comes in, jump on it and respond to it. And I think the same thing goes even internally when you go to court, for example, and you come back and there's 5 new deadlines. Typically, you're going to go right to the paralegal and say, hey, these are the new deadlines, or the rest of the team and say, hey, these are the new deadlines in the case, because you're part of a team. You're letting everybody else know what's happening. And the same thing is, true for email or telephone or whatever, any other type of communication. Informing everybody on what's going on is...
Well, it's being efficient, right? I mean, we can get into productivity and efficiency.
Right, that's all. Yeah.
And all that. But I think that, again, how am I moving it forward? I could go back and I could have the paralegal come find me, or wait for a scheduling order to come through, and I'm hopeful that, so that to me is to us is a no-brainer. I know that's how we do things. But, in terms of clients, when you communicate with them, it's like when you forward something to them, this should be, oh, okay. I know why they're doing this.
You're adding clarity.
Yeah. I mean, like, oh, wait, why are you doing this?
Right.
No, it should be, thank you. They should understand why you're doing this and how it fits within your strategy.
Right. In other words,
because you've already communicated.
Right.
That.
Exactly. In other words, it's a follow-up to another prior communication. Right. You already told them that you're going to court on Thursday for the big hearing. Right. It's not like they're hearing the outcome of a hearing. They're learning about the outcome of a hearing that they never knew was even going to happen.
Or you send them a draft of a motion, and they've already...
They should know what
they should know why.
For. Right.
Like why you're putting this together, why you're filing the motion, what it's about, before they see it. In my view. Yeah. Ideally, listen, there's things that pop up, there's things that happen. It's, we're talking about it in ideal circumstances, but I get that there are times when that's not something that you can control. Sometimes things just happen. Sometimes, your client depends on the circumstances, depends on your practice and your client base. I know our operation is, we want our clients to tell us, stop. That's too much information, right?
Until they don't respond to
because to us, an informed client is best.
Right, but at the same time, we want to be respectful. So we don't want to send a full 2-page update every 3 days. Because they have lots of things to do. Your case is not the only thing this client's dealing with. So you have to be, or we have to be. We're aware of this, to be thoughtful and efficient with how we communicate. We give status reports periodically, not every day. Right. But if, at the same time, if they know there's a big hearing, summary judgment hearing on Thursday, they are going to expect to hear from you on Thursday or Friday, the latest, if it's afternoon or whatever. Yeah. And you can't get to them before then. But I think some of this is, going back to what you said before, expectations, but also remembering that you're part of a team, and obviously the client is a critical part of the team, but all the other people are parts of the team too. And so, going back to the outcome of the hearing, you go to court, the paralegal or whoever's on the team, maybe the associate, didn't get to go with you to court, and you come back, and if you don't communicate to them what happened, they were part of the prep. That associate did the research. The paralegal put together the trial notebook, and so part of, I think, our success is that, we work in teams, but we have everyone is truly an important part of what we do. And so that's the wins and the fails too. It's like if they are just preparing for battle and they don't find out what happens at the end of the battle, that's a little deflating, I think. And also doesn't allow people to feel like they're part of something.
Well, I go back to, I think, what I said about my expectations. How would I feel? Right. I always think about that. If I was on a team, and I was, right, as a young lawyer, right, I was on a team and I prepped. And like, if I didn't go to court, someone else went to court or a deposition or a mediation, and they came back and they didn't tell me what happened or what, how would that make me feel?
Yeah.
And so it's empathy for that, saying, look, they help. They're part of the team. We should have this communication internally. And that's, to me, that's culture, and that's part of our core values and all that stuff, for sure.
Yeah. Well, it's the same thing with even a draft. So if a young associate prepares a draft motion for you and you revise it and just file it and don't tell them anything, well, one, they don't know what happened. Did I have good work product? Is there feedback? Was this... So there's, you've cut off an opportunity for a learning opportunity because you didn't share feedback, but also they don't feel like they're part of something. Their work doesn't count, and they have no sense of whatever community I was going to say, but really of collaboration and being part of it. And I really think that is, we're talking about communication, but that is such an important part of the success of a law firm is building that culture and maintaining a sense of belonging and importance. People want to know, I think lawyers, staff, everyone wants to know that they're part of something.
I agree. So to me, it's, just employ empathy and think about if you were in the other situation, if you were on the other side, what would you want? How would you want it? And when would you want it?
Yeah.
And, just overthink communication.
Right.
Not overthink the substance, but overthink, how should I be communicating? When should I be communicating? And communicate. If you're stifled, talk to somebody about, what you should say.
Right. Yeah.
Don't do nothing, because that's the worst.
Right. Yeah.
That leads to all sorts of issues.
Yeah. If you're on a phone call and they're static, you can let the other person know, hey, I can't really hear you. It's breaking up. But if you're in writing, you don't really have that opportunity.
Yeah.
But the other, it's a little bit more challenging, but to your point, you just have to invest a little energy and think about it more so than when you're just speaking with someone. And
I'm going to drop this, and then I think this could be another podcast. So I'll just drop this and we're going to end, which is sarcasm in black and white does not work.
Yeah. Yeah. I think, I agree with that. Sarcasm in writing does not work. Thank you, Nelson. Thank you for this, Brett. Thank you for communicating with me openly, honestly, frequently. I value it.
Diabolical.
If you like this episode, please give us a 5-star review, follow us, share the episode with your friends and family, and we will see you next time.
Thanks, Nelson.
For more information on this show and other resources, visit fastamron.com and connect with us on LinkedIn, Facebook, and Instagram @FastAmron.